Hello, everyone. So, Blake Lively has just filed a motion to compel. Let's take a look at that. All right. Pursuant to Federal Rules of Civil Procedure 37A, 26A3A, and Rule 5A9 of this court's individual practices in civil cases, Plaintiff Blake Lively respectfully submits this letter regarding Wayfarer Studios, It Ends With Us movie, and Tag. And their exchange of pre-trial materials and disclosures in anticipation of the forthcoming April 10th pre-trial filing deadline. For the reasons explained below, plaintiff requests that the court compel defendants to disclose whether Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel will or will not be testifying in person at the trial set to begin on May 18th, and grant a limited extension. After opposing extensions, she's now asking for one. And grant a limited extension to provide deposition designations for any party who elects not to appear at trial. Pursuant to this court's individual rules of civil practice, parties must identify in the proposed joint pretrial order a list of all trial witnesses indicating whether such witnesses will testify in person or by deposition. Rule 5A9, so that's from Rule 5A9, sorry. This requirement is particularly important with respect to witnesses who have previously provided deposition testimony, as is the case with all of the counsel for defendants' clients, Justin Baldoni, Jamie Heath, Steve Sarowitz, Melissa Nathan, and Jennifer Abel. Each of these individuals remain parties to this case. Yet defendants have refused to answer whether any of them will show up for the trial. Instead, defendants' position appears to be that they are entitled to inform plaintiff at some future undetermined date whether these individuals will provide testimony by deposition designation or live testimony. And just to kind of elaborate on that point, because I'm sure people will be sitting there going, what are you talking about? They're not defendants. But technically they are. So the claims have been dismissed by order of the summary judgment, but judgment has not yet been entered. So until that happens, they are still effectively defendants. Because any of the claims or parties may be revised at any time before entry of judgment. So, yeah. So until the final judgment is entered, they're still technically parties to the actions. So hopefully that will explain that. But that does not mean that the claims have been kind of undismissed or anything like that. Okay. In taking this position, defendants' counsel have taken the curious position that they somehow are unable to determine whether their own clients are unwilling or unable to appear in person. While that certainty may be understandable with respect to third parties, it is obviously inapplicable to Baldoni, Heath, Sarowitz, Nathan, and Abel. Ms. Lively respectfully requests that the court direct defendants to disclose whether these parties will testify in person or by deposition designation by no later than Wednesday, April 8th, so that's tomorrow, and that Ms. Lively be granted a limited extension to provide deposition designations for any non-appearing parties by no later than 1 week from the date by which this information is disclosed by defendants, to provide time for a complete exchange of deposition designations, counter designations, and objections as to these individuals if necessary. By way of background, because everyone loves background, on Friday, April the 3rd, the parties conferred regarding the scheduling the exchange of the pretrial submissions given the court's order and the upcoming April 10th deadline. Counsel for Ms. Lively inquired as to whether the aforementioned clients would be appearing at trial, stating that if not, Ms. Lively would need to accommodate time to include deposition designations in the parties' remaining exchange schedule. Counsel for defendants refused to provide that information, suggesting that their clients may appear live, but also potentially by deposition. After the parties' conferral on April 3rd, counsel for Miss Lively proposed an exchange schedule that included a mutual exchange of witness information and disclosure as to which of their clients would provide testimony in person or by deposition. As of the time of filing, defendants have ignored the full proposed exchange schedule that contemplates numerous deadlines in order for the parties to complete exchanges by April 10th. On April 6th, counsel for plaintiff again requested that counsel for defendants provide the information as to whether their clients would appear in person or by deposition. Defendants' counsel responded with a refusal to provide this information in the near future or in the parties' final witness lists. Instead, defendants' counsel stated in part that given the court's limited subpoena power, we are reserving the right to have witnesses appear by designation if they are unwilling or unable to appear in person, and designating deposition testimony for witnesses who are outside the geographical reach of the court's subpoena power, while reserving the right to present their testimony by designation. Given the parties' conferral and subsequent correspondence, counsel has conferred and attempted to confer in good faith with defendants regarding this issue pursuant to Federal Rule of Civil Procedure 37A1. The presence or absence of these parties at trial will substantially affect the presentation of evidence, including the order of witnesses, the parties' preparation for testimony, and this court's pretrial rulings. Defendants' refusal to provide this straightforward information to Miss Lively appears designed to manufacture a strategic advantage by depriving Miss Lively of information that will substantially influence her ability to complete in a timely fashion the witness and exhibit lists, as well as other exchanges contemplated in the forthcoming joint pretrial order. If some or all of the parties are refusing to appear at trial, Miss Lively is entitled to know in advance. Okay. Accordingly, Miss Lively requests that the court compel disclosure of this information in compliance with this court's Rule 589 and grant a limited extension of 1 week from the date by which this information is disclosed by defendants to provide time for a complete exchange of designations and objections. Lively's also attached, there's like a brief email thread as well, just let's have a look at it, shall we? So this is dated the 2nd of April from Stephanie Rosa at Manat. So let's have a look. Counsel, please let us know your availability to confer with respect to the jury instructions tomorrow. We are available from 1 to 3:30 Eastern Time tomorrow and suggest allotting at least 1 hour for the call. Okay. So who's from Alice Buttrick, who works for Shapiro's firm. Same day, 2nd of April. Thanks, Stephanie. We can speak at 2 Eastern Time tomorrow. We suggest the party should also discuss how today's ruling affects the pretrial exchanges. And then they've got the Zoom meeting link. Okay, from Kristen Bender, Wilkie. We are writing in response to the party scheduling conferral earlier today. So is this after the meeting? Yes, it is. This is the next day. It looks like 6:05, but I'm not quite sure if that's Eastern or Pacific. We are writing in response to the party's scheduling conferral earlier today. In light of our conversation and the court schedule, we agree to continue ahead as to all filings on April 10th. Please see the proposed schedule below. As you noted, all parties continue to evaluate the court's recent order and any potential implications for the case that is going to trial. Ms. Lively also plans to evaluate In good faith, her exhibit list and deposition designations and any revisions will be identified in connection with final exchanges on the date that we have currently proposed for April 8th. The court's pending spoliation ruling may also facilitate further reductions in trial materials. In the meantime, we do not anticipate substantial reduction as to any of the pre-trial materials such that Miss Lively would need to circulate unilateral revisions before the parties can continue their exchanges. Okay. So some proposed dates. So on the 5th of April, parties to exchange revised witness lists, including confirmation of whether witnesses will appear in person or via deposition as required by the court's Rule 589. On the 6th of April, plaintiff to circulate jury instructions and verdict form. Plaintiff to circulate JPTO and summary of the case. Plaintiff to circulate designations as to designations for dismissed defendants appearing via deposition. And in case anyone isn't actually aware, JPTO is Joint Pretrial Order. And the other thing on the 6th, defendants to circulate revised voir dire questionnaires. On the 7th of April, defendants to circulate revised jury instructions and verdict form. Defendants to circulate revised JPTO and summary of the case. Defendants to circulate counter designations and objections as to new designations. Parties exchange updated objections to exhibits, responses to existing objections, annotations for advanced rulings. On the 8th, the last one was the 7th. So this one is the 8th of April. Parties to exchange counter designations and counter designations for initial designations. Parties to confer regarding jury instructions, verdict form, voir dire questionnaires, and motions in limine. Parties exchange final exhibit lists, noting differences, designations, witness lists, and objections. By the 9th of April at 3 p.m., plaintiff circulates a final copy of jury instructions, verdict form, voir dire questionnaire for insertion of defendant's final positions. Plaintiff circulates merged copy of JPTO and summary of the case. Plaintiff circulates counter designations and counter designations for new designations. Parties circulate objections to any additional exhibits designated for the first time on the 8th of April. Then by the 10th of April at 12 noon Eastern Time, defendants circulate final copy of jury instructions, verdict form, voir dire questionnaires with insertion of defendant's final position. Parties to approve JPTO by 3 p.m. Eastern Time. Plaintiff files JPTO. Okay, it seems fairly straightforward. So, on the 6th, Kristen Bender. Because by this point, where is it? Yeah, so the 5th. So, I don't know whether the 5th came and went and nothing happened, but obviously, according to this proposed date for exchange, the parties were due to have exchanged revised witness lists, including confirmation of whether witnesses will appear in person or via deposition. So the next email is the 6th. So did nothing happen? We're about to find out. Well, I hope so anyway. Counsel, pursuant to Lyman's rules. Lyman, we've thrown out judge. All respect is gone. Pursuant to Lyman's rules, defendants must disclose a list of all trial witnesses indicating whether such witnesses will testify in person or by deposition. As of Friday, defendants refused to disclose whether or not their clients, Baldoni, Heath, Sowers, Abel, Nathan, are attending trial in person, and you took the position that we must prepare both for live testimony and deposition designation because either was possible. reserving defendant's disclosure until the time of testimony. With the pretrial filings due on Friday, we need this information immediately. And that's actually fair. That's a fair position. Absent your response by 5 p.m. Eastern, we will proceed to seek relief from the court later today to obtain this information and a limited extension that will permit us to make timely designations as to any such witnesses not appearing live. And, and then we get quite a snarky email from Ellen the Great. We understand the court's rules. Oh, I love it. We understand the court's rules. Just to clear up any misperception, it is not our intention to wait until the time of trial to identify the witnesses who are appearing in person. Rather, given the court's limited subpoena power, we are reserving the right to have witnesses appear by designation if they are unwilling or unable to appear in person. To avoid any potential prejudice, we are designating deposition testimony for witnesses who are outside the geographical reach of the court's subpoena power and reserving the right to present their testimony by designation. Because, I mean, yeah, I think that's probably one area Blake Lively just does not understand is subpoena power, because she'll subpoena anyone. She will subpoena anyone. Subpoena Stephanie Jones for someone's mobile phone information who has, no relevance to any lawsuit that she's filed. Yeah, we'll do it. Subpoena people who have nothing to do whatsoever with this lawsuit. It doesn't matter if they're in America, if they're in Canada, if they're in the UK. Just throw a subpoena out there. It seems to be her answer to all of her problems, and yet she does not understand how the rules seem to go. So now we have a little bit of understanding and a bit of context from Wayfarer's side, because it always sounds fair when you just read Lively side of the story, but then you get Wayfarer come along, add a bit more information and context, which was like completely omitted, and then you're sitting there thinking, okay, yeah, now it all makes sense now. Okay, and then they continue further. We are re-evaluating our witnesses and exhibit lists with an eye toward narrowing the trial in light of the court's very recent ruling. We hope you're doing the same. And again, I think whilst that ruling was fantastic and, trimmed down heavily the, grossly overload of claims that Blake Lively was bringing, they've also got to now adapt everything and adjust everything, because it was like it come at the 11th hour. So I get it. Okay. As always, I like to see what Wayfarer respond with in their opposition to this, because they are undoubtedly going to oppose this. So, yeah, I think I'm going to kind of reserve judgment. I mean, Lively, when you look at what Lively's saying, she's not wrong. But, I understand, I want to understand a little bit more about Wayfarer's position, I think. But yeah, I think I can see Lyman just giving it to Lively anyway, because I just think he will. All right, guys. Yeah, I've got some. I have got more videos I need to do. I need to do something about Blake Lively's Instagram rant about victimhood and speaking for all women and her digital violence. I have a lot to say on that. And I've been kind of trying to compose myself to say something out on that as one of the people she subpoenaed. But I've got to do that, and I will do that really soon, probably tomorrow. I've also got to go through the order. I've looked through it in more detail, and I've got stuff I want to talk about and specific points I want to go through and hone in on. And then I've got an update. We've got a hearing, but it's not until June in the Celeste Smith case, and it will be a public hearing as well. So I still got something I want to say about that situation too. I wanted to do a video on that, but it's been a bit haywire with all this, not just this case, but all the related cases as well. So now I'm able to gather my thoughts a bit more. Okay, guys, thanks for listening.